stunning admission from the White House. Acting Chief of Staff Mick Mulvaney directly contradicting President Trump on a quid pro quo with...
I want no quid pro quo. Quid pro quo. Quid pro quo.
Quid pro quo. I'll scratch your back if you scratch mine. Who cares about the constituents when you have a fat pile of cash? When the price is right, I'll do anything.
America has a problem. For as long as politics have existed, wealthy individuals have tried to pull the strings of power. In the United States, people knew this, and just how unfair it was. In response, the government began to enforce limits on just how much you can donate to a politician. This makes bribery all but impossible. How could you ever bribe somebody with such hopelessly low amounts? Hey buddy, I got 60 cents in my pocket if you outlaw cats. Problem solved. Right?
That's unconstitutional. You cannot limit the spending of individuals. Buckley versus Vallejo says as much. This infringes on our right to free expression. It says right here that the limit on independent expenditures is unconstitutional. Now, if you excuse me, I have some deals to make.
Not so fast. Notice how the court specified independent expenditure. There's a reason they did that. Congress's right to regulate political spending was upheld, but only conditionally. If there's a risk of quid pro quo corruption, like if the donor and the politician are speaking directly, the limits can still be upheld. Furthermore, that protection doesn't apply to corporations, so don't get any funny ideas. This corrupt business of yours is over.
Citizens United extended these protections to corporations in 2010. Now anyone independent of me can donate as much as they want. And that's the root of the critical flaw in your little preventative measures.
But how? This still seems airtight.
Well, you see, Congress cannot regulate donations between private entities like corporations and private individuals.
But that's still...
Shut up and listen to me. Just 3 months after Citizens United, the DC Circuit Court of Appeals extended the same grace to super PACs. They are allowed to collect and spend unlimited money from third parties, so long as they don't directly coordinate or donate to the candidates they support. This applies regardless of possible conflicts of interest within those third parties. In other words, let's imagine for a minute that one of my rich banker friends, we'll call him John, wants to make some changes to banking legislation. He can talk to me, and we can strike a deal.
If you change this law, I'll donate $2,500,000 to your super PAC.
Propose I say yes. Who wouldn't with this much money on the line? Now, it's completely legal for him to donate to my super PAC, though the PAC can't coordinate with me or donate to me. They can run advertisements and other campaigns in my favor with the money given. As long as I never coordinate with the PAC, we're all in the clear. Sounds like a fair and independent arrangement to me.
Holy sh**. If you're anything like me, as soon as you heard about this logical error, you immediately thought, what can be done? And I'm happy to report that the situation isn't as grim as it looks. Now, there are already laws in place to regulate super PAC expenditures. The only reason they aren't enforced is because of that flawed DC Circuit Court ruling. Equal Citizens is looking to bring this case to the Supreme Court, where it can be settled once and for all. We need to cancel super PACs. Wake up, America.
Wake up, America.
Wake up, America.